Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. This is our weekly review, our analysis, our assessment, and our description, our discussion with you of those major areas of law and justice and the rule of law in America and beyond. Thank you so very much for joining me and my producer, Max, once again here on Civic Media as we undertake, as always, an ambitious but achievable syllabus on our weekend broadcast, talking about all of those important things that animate our lives and our livelihoods here in Wisconsin, throughout the United States of America, and also across the globe. No exception this weekend broadcast at all. And so let me talk first a little bit about our agenda, our syllabus for this weekend. We're going to begin with what is undeniably one of the major rule of law stories of the year, happening just this past week. And you know what that is. That is the dismissal, the decision by the Department of Justice, the special counsel, by our Attorney General, Merrick Garland, to abandon those two pieces of major criminal prosecution against a man named Donald John Trump. He is going to become the next president of the United States of America in just about 52 days from now. The decision by the Department of Justice to dismiss those criminal prosecutions underway for a very long time. Prosecutions begun by returns by grand juries, both in Washington, D.C. and in South Florida, finding that the former and future president of the United States of America did in fact engage in crimes, in violations of the federal criminal code in America, including that case in Washington, D.C., alleging election interference, an attempt to overthrow, to undermine the election of 2020. 4 counts there, now dismissed, now taken off the docket of District Court Judge Tanya Chutkan. And in South Florida and in the 11th Circuit, the decision equally important, equally significant, I'm going to argue, as I have in the past, equally catastrophic for the rule of law, to take off the calendar of the 11th Circuit Court of Appeals that until last week, just this past week, the last few business days, had on its docket a determination of whether or not the decision by Eileen Cannon to dismiss the case based upon her conclusion, unsupported by precedent, unsupported by the law, that Jack Smith, the prosecutor in those cases, had no authority to do so, improperly appointed by the Attorney General. That matter pending until just days ago before the 11th Circuit, now removed also from the 11th Circuit calendar almost completely, but with an exception, and that is 2 lingering defendants also charged along with Donald Trump with, yes, that's right, obstruction of justice. We'll get back to that and explain how all of that works. One of the most significant rule of law decisions, one of the most significant rule of law administration of justice events in 2024, arguably in recent years, the determination by the Department of Justice that those cases cannot go ahead, premised upon a policy not applicable right now, that a sitting president cannot be subject to prosecution. We'll get back to all of that, explain what's going on there, why those decisions by our Department of Justice so important, so disappointing in terms of what could and should have happened to ensure that we have information, we have insight, we have legal perspective on unresolved questions that, yes, indeed, would never see the light of day in the context of a trial in either the Washington insurrection case or the South Florida case, but nonetheless, important for the future of America, very significant for the rule of law. All of that abandoned by the Department of Justice just this past week. We'll review again what the status of that New York case is, still pending in front of Juan Merchan without a sentencing date of the defendant. His name, once again, Donald Trump. No resolution yet on an underlying immunity decision there. No resolution yet on any sentencing. And exactly what's going to go on there, we'll talk about that again, as we did last week, and update you in that matter, and then also simply reaffirm the status of that other state case pending in Georgia. That case pending before the Georgia Court of Appeals, talking about, in the end, the way that virtually all of these criminal cases brought by grand juries upon findings of probable cause that Donald Trump engaged in crimes against the state of New York, state of Georgia, against the federal government, all of them almost certainly finishing now with a whimper and not any final judgment, which is commonplace, which is traditional, which is usual, which is expected for every other criminal case in America, state cases, federal cases alike. We'll talk more about that at the top of our discussion here on Amicus, a law review. Then also going to return to a common subject matter here on our weekend broadcast, and that is, what is the Supreme Court doing? What are those 9 justices of our high court? What are they up to these days? We know that they have just recently begun their 2024-2025 term that lasts, yes, indeed, until late September of next year. Anticipating once again in May, probably June, maybe into July as well. The return of major cases. We'll talk about some of those. We'll talk about a major decision made by the Supreme Court just this past week to take on another case that reaffirms its continuing focus on, its continuing emphasis on agencies in America. In the political spectrum, we have seen that in the area of attacks on the so-called deep, dark administrative state. It doesn't exist. We've got wonderful, outstanding tens of thousands of civil servants out there doing their job based upon their expertise, their insight, their perspective, their experience. Nonetheless, in the political arena, an awful lot of garbage language and inappropriate discussion about how our agencies are somehow undermining America by engaging in conduct about which we know nothing. Nothing could be further from the truth. And yet, in the Supreme Court, we have seen in the last term an attack upon agencies. Remember that Loper Bright Enterprises case that basically for the first time in 40 years removed from the quiver, if you will, of federal district court and appellate court judges the capacity to defer to agencies based upon their expertise, that thing called Chevron deference. That now wiped off the calendars, wiped off the dockets, wiped off the bench books, if you will, of judges around the country, no longer required to defer to the wisdom and the insight of those agencies. Well, the Supreme Court's at it again this term. They have taken on a number of cases in the area of environment, in the area of economics, other things out there. And just this past week, adding to that, yet another case, a fresh challenge to agency power, this one having to do with the Federal Communications Commission and its authority to implement a policy that would have brought broadband and other telephone services to rural communities, to impoverished communities in our nation across the board, bringing those services to neighborhoods that have not yet had them, not been exposed to the communication possibilities of the 21st century. A decision by a lower court, yes, that's right, it's the Fifth Circuit once again, finding that the Federal Communications Commission overstepped. Now that case before the Supreme Court, and significantly, another doctrine almost certainly going to be attacked and probably overturned by the Supreme Court, and that is a doctrine involving discretion. That is the discretion of agencies to act as they should according to congressional delegation. And yes, this doctrine is the non-delegation doctrine. We'll talk about what that means. We'll talk about why it's important and why this decision of just this past week on the Supreme Court docket to take on this new case signals yet again the Supreme Court's not done. The Supreme Court is not yet done in addressing a problem that does not exist, and that is this notion that, again, our agencies are somehow out there without any tether, without any guidelines and standards, and they need to be reined in. All these doctrines that have worked for centuries of American history, more recently decades of American history, this particular doctrine, the non-delegation doctrine, out there for about 84, 85 years, likely to be overturned by the Supreme Court. And once again, an attack upon a diminution of the power of our agencies to work on your behalf and my behalf, our behalf, and making certain that government goes. We'll talk all about that, in addition to reminding you about what the Supreme Court is also doing just this coming week and in the months ahead. It's a Supreme Court docket. It's Supreme Court review through the oral arguments that it does routinely. We've got 4 of them coming up just this week. They are scheduled through January and February, and now even into March of next year, among the almost now 15 cases, 50 cases on their docket. We'll talk about the Supreme Court in some detail in this edition, this broadcast here on our weekend show. Then in our second hour, we're going to go overseas once again, as we sometimes do. We did last week to talk about a number of different lessons to be learned from various places around the country, including France, including Brazil last week, including the International Criminal Court. This week, we're going to focus on Australia and Great Britain. Some very interesting legislation passed in both of those nations, one of them having to do with social media access for people under the age of 16, an issue that also reverberates here in America in connection with another Supreme Court case right now pending, coming out of a couple of state legislatures. And coming out of Great Britain just this past week, decisions to go ahead with an assisted dying piece of legislation. We'll talk about that as well, and its implications for us here in America as we think about those issues too in our nation. And then finally, a couple of very domestic, very relevant issues on our docket. One of them having to do with the return of Bible studies in the public schools, at least in Texas, maybe other places as well. We'll talk about what happened just this past week in Texas, authorizing what might be interpreted, what might in fact come to be a limited rescission of what the Supreme Court said way back in 1963 when it said that, you know what, you cannot be teaching the Bible in our public classrooms. You can read the Bible privately. Students can thoughtfully, pensively ponder and review and examine those religious texts of all the religions, but they cannot be taught that in the schools. Coming back in Texas in many ways, we're also going to chat about white supremacy and some very disturbing statistics about the return, if it ever left, of white supremacy in America. Some very disturbing statistics there that also describe, regrettably, some areas of our nation across the country where instances of white supremacy by small groups, by larger groups, are once again influencing our nation. All of that coming up on our weekend broadcast here on Amicus, a Law Review. This is Amicus, a Law Review. My name is Jim Santelle. This hour and next hour are also joined in the studios of Civic Media here on our weekend broadcast as my producer Max, and together We are also taking your questions, your inquiries at 855-752-4842. That telephone number, once again, is 855-752-4842. Max and I interested in soliciting and responding to your inquiries and questions about anything on our syllabus, our ambitious syllabus this weekend broadcast. Also, encouraging you to drop into our text line, into the drop box of Civic Media, any of your questions and comments as well, and we'll take those up during the course of this hour and next hour as well. This hour beginning, as promised, with a review of what I regard, I suspect you do too, one of the major decisions in rule of law jurisprudence just this past week, and that is this major decision after years of investigation, after years of prosecution in the federal courts in the District of Columbia, the district court there, going up to the appeals court, going up to the United States Supreme Court, and then also in southern Florida, the district court there in Fort Pierce, Florida. Both of those cases, one is the insurrection case, the election interference case, charging Donald Trump with 4 counts of violations of federal law when it comes to an attempt to undermine, to rescind, to overthrow the election of 2020. And the prosecution, of course, in South Florida, that's the so-called Mar-a-Lago national documents, classified documents case. That's the one in which the defendants, plural, are alleged to have taken, retained, and then also obstructed justice in an attempt to try to cover up what they did. Numerous documents coming out of the White House, documents to which the president and these others did not have entitlement. And in the wake of decisions in both of those cases, another decision just this past week by the Department of Justice not to pursue either one any further. How do these cases come about? How do these major decisions that we have talked about before, why are they so important for us in America? Well, we know about the District of Columbia case. That, once again, is this major case that spawned all of this litigation about whether or not a president is immune from prosecution for crimes, C-R-I-M-E-S, criminal conduct in the White House. And the Supreme Court saying on July 1 of last year in this wild, this offensive, this constitution-changing decision of July 1, that indeed, for the first time in 248 years, it turns out the Constitution does, in fact, vest in a president, if we elect that president, the complete authority with respect to the Department of Justice, absolute immunity for anything that he, one day she, does in connection with relationships there, communications there. With respect to virtually everything else, presumptions of immunities for all the other conduct of a president. Never before seen a document like that. And again, predicated upon this notion that the president is all powerful, needs to be muscular, needs to be deft and very, very, very quick in moving on policy and practice. And that's the reason why we cannot have a president, according to John Roberts and 5 other members of the Supreme Court, cannot have a president who is somehow burdened with the criminal prosecution that would come in the wake of crimes that he or she may commit. It is a stunning opinion back in July. Now, from my perspective, and I suspect from the perspectives of many of you, including other Americans across our nation, around the world, now also affirmed by our Attorney General and arguably by the special counsel as well, as they abandoned the very case upon which that decision was premised. You may recall well that the Supreme Court has sent back to Tanya Chutkan, the district court judge, the responsibility for doing some homework, now trying to figure out what that opinion means when it comes to applying it to the 4-count superseding indictment pending in front of her. You may recall as well that in the wake of that return of that case, sending it back down to her, what did she do appropriately? She indicated, I'm going ahead with this. I'm going to begin to pursue now, after the Supreme Court, the next steps in all this. She solicited from the parties. There are statements about what should and should not happen. And you recall well that Jack Smith had submitted this omnibus, well over 100-page document outlining exactly how we could try this case, even in the wake of the Supreme Court, in the wake, yes, indeed, of a superseding indictment that changed somewhat some of the charges in response to what the Supreme Court had done. He outlined that in great detail, then followed that up with a huge compendium of documents, also would have been presented to the trial court. And it was in that setting that the district court judge Tanya Chutkan had also asked the defense, as judges always do, what is their position? What is Donald Trump's position on what should happen? And contrary to what Jack Smith was saying, the defense has said, no, you can dismiss this case. There's nothing to try here anymore. And so Tanya Chutkan, they said, again, in opposition to what the Department of Justice was saying, they said, get rid of this case, dismiss it. And it was in that setting that a significant thing happened, and that was November 5th, in which the Supreme Court and all the rest of us looked on as America elected Donald John Trump as its next president of the United States of America. Now, why is that important? Why should that be important in connection with a continuing criminal prosecution? Often, as we've said in the past, elections and prosecutions can live side by side. They're always a part of the same system of rule of law. They're different things, but they can, in fact, should, and always have lived apart from each other in terms of one not influencing, not overtaking the other until this past week. Why? Because internal, as you well know from past history, including the Mueller report of a number of years ago, this is when this first sort of came into the public domain, this longstanding, decades-old policy, probably anachronistic now, probably should be changed by an attorney general. This policy internal to the Department of Justice that says that we do not prosecute, we do not charge, we do not pursue criminally sitting presidents of the United States of America. Important emphasis on the word sitting, S-I-T-T-I-N-G, the present incumbent of that office. And that's the reason why way back at the time of the Mueller investigation, the investigator there, the special counsel, Bob Mueller, determined that he could not prosecute a sitting president. His name was Donald Trump then. It still is Donald Trump. Why? Because he was sitting. He was in the office at the time, and so referred the case, the entire matter, on to Capitol Hill, where the Congress decided not to do anything with it. In the wake of all of that, we come now to the next invocation of that principle, just applied just this past week, and that is Jack Smith announcing, probably, my guess, not completely satisfied with this result, but announcing that because Donald Trump is about to become the next incumbent of the White House, because that's going to happen soon, necessarily, that same principle that prevents a prosecution of a sitting president now applies to him, basically expanding that principle, that policy, to include a private citizen. His name, again, Donald Trump. And because of that, anticipating his presidency, anticipating that he is going to encumber that office, and therefore anticipating that the policy would apply on January 20th, dismissing now some 50 or so days before he becomes the president, dismissing those criminal prosecutions in Southern Florida, actually pending before the 11th Circuit, and also before Tanya Chutkan in the district court. Both of those motions made requesting leave of court to dismiss, asking the judges for permission to get rid of them. And both of those granted just this past week. As Amicus, a law review will continue, we were going to discuss further about why that's important, what we have lost in the wake of those decisions, and then also talk about the other cases here on Amicus, a law review. Jim Santelle. I am your host here on the broadcast stations of Civic Media, both this hour and next hour as well for Amicus, a law review. This, of course, our regular weekend review of all things justice related. This broadcast, no exception to that. Commenting, offering some perspective on this major rule of law issue that happened just this past week. That is dismissal, the bringing to an end, the abandonment of these major federal criminal prosecutions against Donald Trump. An awful lot of focus by people saying that, well, Donald Trump escaped justice. He got away with it, as some have said. And indeed, that interpretation of the law and of what happened here is not an inappropriate one. But my concern is greater than that, and it comes from two different sources. One of them is, of course, what I implicitly described in our previous segments here on our Saturday and Sunday broadcast, and that is that there are principles out there that contemplate applications of policies and doctrines that apply right now and may or may not apply in the future. And so, as I have done in the past, invoking once again Yale professor Timothy Snyder, who talked about times of transition, times of concern about the future, and said, do not obey in advance. He said this: most of the power of authoritarianism is freely given, he wrote. In times like these, he wrote this way back in 2017, so not speaking specifically about 2024 into 2025, but times generally in the 21st century. He said, in times like these, individuals think ahead about what a more repressive government will want and then offer themselves without being asked. And finally, he says, a citizen who adapts in this way is teaching power what it can do. That, according to Timothy Snyder in his writing about all sorts of things, lessons from the 20th century about how we should behave in the 21st. And why is that significant? Because the dismissal of these cases, from my perspective, and I suspect from many of the perspectives that you share with me, is premature. The policy upon which it is premised does not apply. And the policy probably should be rescinded anyway. This Attorney General, Merrick Garland, probably, like previous Attorneys General, has complete authority to rescind this policy at any time. It is implicitly an acknowledgement of what the Supreme Court told us back in July of this past year. That is, that presidents are kings and they're not subject to the rule of law like the rest of us are. When you establish and then you apply a policy that says that the chief federal law enforcement officer in the nation does not have to apply by the rules and does not have to obey the basic norms and standards by which the rest of us live, including compliance with the federal criminal law, you're basically saying that we have established a supreme presidency. We've established a kingdom once again, as Sonia Sotomayor and Elena Kagan and Ketanji Brown Jackson articulated so eloquently back in July. And along the way, with respect to this particular policy that says a sitting president cannot be prosecuted, cannot be charged, cannot prosecute a case against him, you are doing it, as Timothy Snyder said, in anticipation of something happening. You are obeying in advance and teaching what it can do, anticipating a future government and offering ourselves without being asked to do so. About 52 days or so until the presidency changes and Joseph R. Biden becomes a private citizen and Donald Trump once again becomes the president of the United States of America. But right now, this weekend, this Saturday, this Sunday, the reason why the policy doesn't apply is that Donald Trump is not a sitting president. And so, for the next 50 days or so, possible for these prosecutions to go ahead, not to trial. They will not see the light of day under any circumstances that are even vaguely imaginable. These cases will not go to trial, but there's something else. And this is the real reason why I am so concerned about the decision by our Attorney General, by our Department of Justice just this past week, to abandon these cases prematurely, to tell power what it can do, and to do it, most importantly, before some very significant rule of law decisions could have been made. And those, of course, relate to unresolved issues, both in that district court case and also in the case in Southern Florida. Momentous, unsettled questions about constraints on criminal wrongdoing by presidents are now left unresolved for now and in the future. Scope of presidential immunity and the capacity of special counsels to do their jobs as they've done in the past several decades. And both of those, I would offer, are incredibly important things for all of us, not just to know on all sides of the political aisle, but significant for the future enforcement of the very laws under which we live and breathe. The case, once again, the dismissal of the case in the District of Columbia, the dismissal of the case in South Florida, yes, prompts a lot of people to say that Mr. Trump, Donald Trump, escaped any criminal accountability for his actions, and that is certainly true. But it also means that these two open constitutional questions of great importance go unanswered. No definitive answers as Donald Trump takes office. One of those questions, again, is the extent to which the protection from prosecution that is now offered to presidents by the Supreme Court ruling back in July, whether that does in fact mean something. What is the full definition of the immunity? That was the homework given by the Supreme Court to Tanya Chutkan for acts taken while in office. Were those private? Were those public? Were those official? Were those unofficial? There is a great benefit to the rule of law and, frankly, even to the law of the case to know what the result of that would have been. It would have been intellectually interesting, yes, but more importantly, significant as a constitutional matter as we approach the 250th anniversary of our nation, to know whether or not this particular set of crimes could in fact have been prosecuted. And that is what we will forever be denied by virtue of the fact not only that the special counsel moved for leave of court to dismiss these cases, and also by the fact that Tanya Chutkan very promptly granted those motions. That case is over. It is done and is now taken off her docket, and we will never know that very important thing in that case. A lot of people saying, well, wait a minute, was dismissed based upon a notion that it might be revived at some point. It was dismissed upon the understanding that it is being done without prejudice. That's the term under which the judge granted the motion to dismiss the case without prejudice. What does that mean? It means that the government can, in fact, bring it again, could reconvene another grand jury, in this case, a third grand jury, to determine whether or not there's probable cause. And yes, indeed, there's a very remote, basically non-existent option for doing that. Why? Because you still have to contend with an appropriate thing called the statute of limitations. And the statute of limitations basically expires on anything related to January 6th of 2021, 5 years from the date or dates of those events, and that brings us to 2026. That will be somewhere in the early years of the incoming Trump administration. Highly unlikely, most likely not a possibility that this case would be resurrected. Under what circumstances, impossible to know. And so that is an empty shell. That is an empty argument to maintain that somehow there could be a resurrection of these charges even during the coming Trump administration. There's a second pushback on this notion that this is not a miscarriage of justice to dismiss these cases, and that is that, yes, indeed, Jack Smith is now working on his final report, and we will see that, and that will be interesting, again, as an historical piece. We know much of what he will say. He's already filed that omnibus briefing statement to Tanya Chutkan. And we know pretty much from the media and also the documents attached to his own document what that trial would have looked like. But that report will be significant. What it is not is a resolution of the judicial decision that Tanya Chutkan had before her until early this past week. That is now gone. And so the case basically is gone. Jack Smith and others plainly finishing up on that report and will be leaving sometime soon in the wake of this abandoned prosecution under circumstances in which this did not happen. Similarly, the other major constitutional question, procedural question, is whether a president who's suspected of committing crimes, whether the Justice Department can avoid conflicts of interest by bringing in an outside prosecutor, these special counsels, to lead a semi-independent investigation into this matter. The judge there, her name is Eileen Cannon, said, no, you can't do that. Only the president can appoint a special counsel. The attorney general cannot do that. She made that decision contrary to Supreme Court decisions, contrary to the precedent that's been in existence for decades, but she made that decision. And that was the decision that was up on appeal to the Court of Appeals for the 11th Circuit. We will now, in the wake of the decision by the attorney general to abandon these cases, never get a 2024 reaffirmation of the capacity of special counsels to do their jobs.
also a very important thing, not just for us to know academically, but also for the future of the Department of Justice, for the future administration of justice principles. If there are circumstances where special counsels need to be appointed by an attorney general, who does that? Well, we think the law still is that an attorney general can do that, but certainly put into some question by virtue of what Eileen Cannon has done. Very good, very right, very decent to know from the 11th Circuit that Eileen Cannon is wrong. Once again, the law remains as it is. Lots of things unresolved, lots of things undefined now that are important to the future of our nation. All of that thrown on the fire pit in the wake of the dismissal by our Attorney General, by the Department of Justice, of these two cases that not only apply a principle that doesn't apply right now to a private citizen, but also by virtue of doing this, effectively embracing the very notion that we've railed against, so many of us in America, this July 1 decision that there is someone who's above the law. Right now, the Supreme Court, that decision is looming large, not only telling us about a hugely powerful presidency, but also now, based upon the application of this inapplicable policy that a sitting president cannot be prosecuted, extending that to a private citizen. If you are going to be the president of the United States of America, we're going to forego the next almost 2 months when good things could have come out of those cases. We're going to forego all that. We're going to apply the principle to protect even you. And we are effectively going to obey in advance. We're going to teach power what it can do. And we're going to offer ourselves without being asked, in the words of Timothy Snyder. An unfortunate and very disappointing development in the rule of law. Of course, we also have those two other cases. One of them is still pending. Actually, two of them still pending. One of them still pending in Manhattan. That's the case in front of Judge Juan Merchan. We talked about this in our previous broadcast. He is now determining what to do also in the wake of the election of Donald Trump. Does he dismiss that hush money case, that state case involving 34 counts of conviction? Donald Trump, a convicted felon coming out of the Manhattan criminal court. Does Juan Merchan dismiss that, knowing that Donald Trump is going to be the president? Or does he, as the district attorney has proposed in that case, does he somehow put all this on the shelf? And does he freeze it for a number of years until after Donald Trump's next term of the presidency? Neither one of those an appropriate and right and rule of law-based proposal and approach to this. What plainly the court should do in that case is do what we do in all the other criminal cases in America, federal and state, and that is sometime in the next 50 or so days, plenty of time in which to do it, should summon Donald Trump in, issue the judge's decision, that is, on the inapplicability of the immunity decision to this particular case, this state case, again, involving a private citizen way back in 2016, and then proceed to sentence him. That should have been done just this past week. According to the judge's own schedule, he suspended that. No new date for sentencing. He is wrestling now with what he describes as one of two alternatives: dismissal outright, which once again would be an affirmation of what the Supreme Court said, that indeed a president is above the law, not even subject to sentencing for a criminal conviction entered by a jury of peers unanimously beyond a reasonable doubt over a 7-week trial period. Finding in the end that that's meaningless and that in fact the case now should be dismissed, basically absolving Donald Trump of that responsibility determined by a trier of fact. Again, standing the rule of law on its head. We don't know exactly what Juan Merchan will do, but the other alternative on his docket proposed by the district attorney is once again to suspend all this for years. Equally inappropriate, equally unjust, if you will, in terms of bringing this to resolution, especially when you can do it promptly. You can do this in a day. Anytime between now and January 20th, all of that could be done. And yet we'll take a look down the road what happens in the weeks ahead in that case, and also the Georgia case, which is also pending still before the Court of Appeals. All of that a matter of discussion here on Amicus, a law review.
This is Amicus, a law review. My name is Jim Santelle. Thank you for joining me and Max for this, our weekend broadcast about all things justice related. Turning now in this, our final segment of our first hour and continuing into the second hour of Amicus, a law review, a return to one of our common subjects, and that is the United States Supreme Court. Yes, that's right. It continues to do things there in Washington, D.C., right across the parking lot from the United States Capitol building, right down the street from the White House, and yes, just within walking distance of the federal district court, where until this past week, Donald Trump was a defendant in that insurrection case. All of that within walking distance, as you all well know, in Washington, D.C. The Supreme Court right there on Capitol Hill, active in this, its 2024-2025 term. We have talked a lot about some of the statistics here. It's important to update where they are, because to this point in their term, they have granted certiorari. That, once again, is that legal term, that Latin term that says we're going to review what a lower court, typically a lower appeals court, has done. Sometimes a Supreme Court coming out of a particular state. We've seen that too. We're going to review what the lower court has done, determine whether or not they've applied the law properly to the facts, whether there's some error that's been made, or they've gotten it all right. They have done that now in this term, granted certiorari in 47 different cases. They come from all different circuits. Significantly, where do they come from? Well, yes, indeed, the Fifth Circuit, which produces last term and this term, apparently once again on track to produce the greatest number of cases from any of the circuits nationwide. Whopping 10 different cases from the Fifth Circuit alone. The Supreme Court taking a lot of those cases. The track record on that, plainly, has been to reverse a lot of what the Fifth Circuit does at the Supreme Court level. Five of them from the Ninth Circuit, which is that huge district out there in the West, including California, that circuit that usually has the highest number of cases coming from its court to the United States Supreme Court. There are two from our circuit, the Seventh Circuit here, Wisconsin, Illinois, and Indiana. And there are somewhere between 1 and 4 other matters being heard from each of the other circuits in the nation. Up to this point, there have been 16 oral arguments, which, yes, again, you can hear. You can hear them live when they're conducted. You can hear them on tape by going on to the Supreme Court docket, going on to the Supreme Court website, and listening to the Supreme Court justices, all of them sparring with, arguing with each other sometimes, but most often with counsel appearing in front of them. 8 more arguments are scheduled for the month of December, coming up fairly soon. 9 in January, 4 in February, and 2 way out in March. And again, more to be argued, more to be decided in the coming months, plainly until May or June, July of next year. They've only issued one formal opinion up to this point, and that had to do with a procedural issue in a death penalty case. And that case going back down to the lower court for some additional fact-finding. Let's talk about what's going on in the near future here just this past week and coming up in the coming week itself. Well, among those 47 cases, it's very clear that the Supreme Court is going to take another look at, another attempt to address this thing called agency discretion, agency expertise. You recall well that in the past term, the previous 2023-2024 term, right before it issued that major, terrible decision on presidential immunities, the Friday before it issued this decision in Loper Bright Enterprises versus Raimondo. That was the case in which the Supreme Court overturned 40 years, 4 decades of tradition and history. They rejected the notion definitively of what's called Chevron deference, that is relying upon people who know what they're talking about, relying upon the experts in agencies to give the courts a sense of what is right and what is good and what is decent. They said no more. We don't need to defer anymore. And so in Loper Bright Enterprises, the Supreme Court took this major wrecking ball to the independence, if you will, the discretion, the judgment, the expertise of our agencies, and saying that judges no longer have to comply with that doctrine. They went on in a case called Jarchese, you may recall, versus the Security and Exchange Commission, prohibiting the use of some administrative mechanisms to combat securities fraud. In that case, another attack upon agencies. Well,
You might have thought that the Supreme Court is now done with that issue, but no, indeed, it is not. Has a number of cases, as you know well, in this term alone, involving the ATF and other matters out. The Environmental Protection Agency is also in its eye shot here and its focus as well, including the Federal Communications Commission, in a case in which they're reviewing, at least the predicate for this is they're reviewing a program of the Federal Communications Commission to bring telephone and broadband services to some impoverished communities and rural areas throughout our nation. This is an administration proposal of the FCC to encourage communication, telephonic, broadband services to places where up to now, believe it or not, they still have not had those kinds of access to good communication across our nation and locally as well. So an attempt again to bring those mechanisms, that technology, to communities that have been underserved up to this point. And of course, that is challenged. That is challenged in a case called Consumers Research. That's the party that's challenging this program of the FCC. And it's opposed by a group, not surprisingly, called the Schools, Health, and Libraries Broadband Coalition. They're in favor of communication. They're in favor of education. Imagine that in all of our areas, including those that have not been sufficiently wealthy and sufficiently affluent up to this point to have those kinds of communication accesses. And so this goes up to the Fifth Circuit. Once again, the Fifth Circuit says, nope, FCC, you can't do this. The Universal Service Contribution Mechanisms, that's the mechanism by which this is being done and financed. It is incompatible with our constitutional structure. That's the way that the appeals court says. This is unconstitutional rules that it cannot be done. And the petitioners, again, take this up to the Supreme Court. And just this past week, the Supreme Court has indicated that it will review that case. And along the way, it will review something called the non-delegation doctrine. The non-delegation doctrine, in particular, in support of the review of this case, Supreme Court Justice Sam Alito wrote this. He said, since 1935, this court has uniformly rejected non-delegation arguments and upheld provisions that authorized agencies to adopt important rules pursuant to extraordinarily capacious standards. Capacious, a word that at least I don't use routinely, but capacious meaning broad and expansive and all kinds of things underneath the umbrella. He says, I support the effort to reconsider that approach. As Amicus, a law review continues, we'll talk about what the non-delegation doctrine is all about, why this case is so important, a continuation, once again, of the attack of the Supreme Court upon our agencies in America. Stay with us for that discussion of the Supreme Court and much more here on the broadcast stations of Civic Media.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle. In this, the second hour of our weekend broadcast, talking about all things related to the administration of justice in the United States of America and beyond, and in particular focusing in the next segment or so on a common theme here in our broadcast, that is the United States Supreme Court once again taking up what many are calling a renewed challenge to agency power in the wake of what it did the last term in rejecting this notion of Chevron deference, this idea that agencies know what they're doing, that expertise should be relied upon. No more in the wake of 40 years. Well, now we've got another doctrine called the non-delegation doctrine. It's been out there, at least in its non-application, following all those double negatives, in its non-application about 85 years. And so the Supreme Court primed, it seems, to reverse tradition that has been in place for 85 years or so. Well, now, what does the non-delegation doctrine say? Well, as we all know, the United States Congress is the entity in our government that passes laws, and they vest in the various agencies, including the Federal Communications Commission and all the other agencies over which they have some administrative authority and some constituting authority. They vest in those agencies responsibility for making decisions about cases in particular. Basically, the Congress is delegating to those agency officials, which, yes, have expertise and insight and experience, delegating to them the responsibility for actually implementing the broad principles of the legislation itself. It's a fairly straightforward doctrine. The non-delegation doctrine would be an attack on that says, no, Congress cannot delegate that responsibility. Congress has got to implement, they've got to describe, they've got to effectively be in the weeds on all the particulars when it comes to applying the laws that they pass. So they cannot delegate, members of Congress, the Senate, the House, cannot delegate those responsibilities to the agencies. It's all got to be defined. Absent that, the agencies have no authority. And the reality is that this so-called non-delegation doctrine has been dormant. It has not been used. It has not been used by the Supreme Court, by the lower courts, the appeals courts, the district courts since 1935 or so, when the Supreme Court was striking down some New Deal laws. Remember those in history? For granting too much leeway to agencies with insufficient guidance. It has been dormant since that time. Basically, an affirmation since 1935 that, yes, indeed, agencies know what they're doing, and they can, in fact, act reasonably in the wake of delegations to them by the Congress and authority vested in them to act reasonably and rationally. Well, that issue, that 85-year tradition, may now be on the chopping block. What do we know? Well, we know that the dispute that prompts this particular case, a case in which the Supreme Court's just granted certiorari is going to review this case probably for oral argument this spring, actually two consolidated cases called FCC versus Consumers Research, and another one called Schools, Health, and Libraries Broadband Coalition versus Consumer Research. Both of those cases have to do with an $8 billion with a B dollar fund that helps pay for telephone and broadband services for impoverished communities, residences of our rural areas throughout our nation. It's overseen by the Federal Communications Commission, that's their agency, and the Universal Service Fund relies on charges imposed on phone bills. That's how it's funded. So again, this is an attempt to bring communication bring the internet, bring telephone services to rural and other impoverished communities nationwide. Consumers Research, which is this group that's challenging the law, says it grants the agency too much discretion. And it also said the FCC has acted unlawfully in letting a private entity administer the fund, kind of a collateral issue there as well. The U.S. Court of Appeals, as I indicated right before our top of the hour break, said, yeah, they're right. The program is invalid. It's an inappropriate
usurpation of congressional action. The agency, the FCC, cannot do that. It's unconstitutional. The Biden administration has asked the Supreme Court to intervene, and indeed they did just this past week. If left in place, the administration said the decision will upend the universal service programs to the detriment of millions of consumers nationwide. That's being said by the Biden administration in support of this FCC program now being challenged, and challenged in part upon the notion that the non-delegation doctrine prohibits the FCC from doing this. Congress cannot delegate to the FCC the authority to spend this money because it's not sufficiently specific. They cannot do this constitutionally, effectively seeking to revive, after 85 years, this non-delegation doctrine the Supreme Court has not embraced at all in the past 85 years or so. And again, right before the break, commenting upon Justice Sam Alito's comment way back in a couple of years ago, saying, it's time for us to revisit this. Maybe we should revive the non-delegation doctrine once again, because the agencies, maybe including the FCC, have been exercising too much power. It is, as I have commented in the past, it is another incarnation in the courts of this attack upon agencies, this notion that somehow we've got a deep state of people and experts who are doing things opaquely without our supervision, without our knowledge. It's ridiculous. It is completely unsupported by what practically happens in America. But nonetheless, it has taken hold in the political realm, and now it's taken hold in the United States Supreme Court. In addition to Justice Alito supporting this, 3 other members of the court, the Chief Justice, his name is John Roberts, Justices Clarence Thomas, Neil Gorsuch, have said that they were also ready to act right away. So we've got at least 4 of them, plainly, who said, yes, bring this case on. Maybe it is time to revive the non-delegation doctrine and once again strip authority from our agencies, including the FCC, to do these kinds of things. Yet another attack. Probably we won't see it until the springtime, but certainly a decision on this in May or June or July of this coming year, 2025. It goes on. And the decision by the Supreme Court to continue to address that particular attack upon this agency, other agencies as well out there, is a subject matter that plainly remains on their docket. Also on the docket, of course, are oral arguments. And it is important to note that this coming week, the Supreme Court back in business once again. 4 different oral arguments. We know what those are about. Let's talk about 2 of them. On Monday, December 2nd, we know that there is a major case that we've talked about before. This is the so-called e-cigarette case. This is the vaping case. The Supreme Court is going to determine whether or not a lower court was right in its decision on a decision by a federal agency when it comes to approving or not approving the authorization to sell and distribute e-cigarettes. That's coming up this coming Monday. The vaping case coming up before the Supreme Court. Be interesting to listen to them. Again, you can listen to that live on the Supreme Court website. And then there's this other major case we've also talked about. It's called Scrimeti. And this is the transgender case, a major case coming out of at least two legislatures in our nation. And those particular laws, Tennessee and Kentucky, prohibit medical treatment for the purpose of attempting to alter, according to the Kentucky law, the appearance of or to validate a minor's perception of a minor's sex, basically prohibiting medical treatments that permit youth to begin to engage in transgender treatment, prohibiting that and under a number of different circumstances. The Tennessee law specifically forbidding medical treatments to allow a minor to identify with or live as a purported identity inconsistent with a minor's sex, or to treat, again, this is directed at the doctors, to treat purported discomfort or distress from a discordance between the minor's sex, that of course referring to the minor's identified sex at birth, and asserted identity. In other words, stopping medical treatment, stopping puberty blockers, certainly stopping surgical procedures at any time for youth who are seeking transgender medical care and counseling. and certainly the medical treatment themselves. The question is raised whether or not that kind of legislation in at least 2 states violates the Equal Protection Clause of the 14th Amendment. It is significant, of course, not only because of the importance of understanding how broad the 14th Amendment, that Equal Protection Clause is, but also noting that the Sixth Circuit reversed a preliminary injunction of the District Court for the Middle District of Tennessee and the District Court for the Western District of Kentucky, and remanded the case back to the lower court for more action. All of this then is followed by the Supreme Court's review. And yes, indeed, that case, Scrametti is the name of the case. It is coming up for oral argument this coming Wednesday. The case is spelled Skrmetti, a case scheduled for oral argument for our United States Supreme Court on Wednesday, December 4th. One of the first, if not the first case addressing transgender issues, transgender rights in front of our Supreme Court. How are those consistent with, or perhaps inconsistent with, the 14th Amendment? All of that being argued. Of course, there's another case that's percolating up out there. It has not yet reached the Supreme Court, and it is another transgender case. This is the one under Title IX. It's the one that addresses whether or not Title IX has limitations on or opens avenues for transgender sports participants and other things in the educational area based upon transgender status of students. That's the academic side of the transgender issue. That case may well be among the future ones that the Supreme Court grants cert on sometime during this term. Again, it's decided that it's going to hear about 47 cases, probably has at least 13, 14, 15 more cases to fill its docket before it is completely done. But Scrametti, again, a major civil rights case, a major human rights case coming up for decision ultimately in May, June, July of next year. But for our argument, where we'll get a pretty good sense from the Supreme Court justices about how they feel about transgender rights in America. And that also, you've got access to that by going into the Supreme Court docket and going online and listening to them argue that live this coming Wednesday morning. All that coming up in the Supreme Court as it takes up, as we know, many other cases out there. We talked already about this broadband case, the latest attack upon the so-called administrative state. We've talked previously about this ghost gun case, the regulation of ghost guns by the ATF, and the determination about whether or not that can stand. We'll talk more about other things on the docket of the Supreme Court as Amicus, a law review, continues.
My name is Jim Santelle. This is Amicus, a law review, reviewing the things that are on the docket of our highest court. Yes, very active court this month, next month, December, January, February, March, oral arguments scheduled on many, many different things, some of which we've discussed, some of those other cases for discussion in the future as they come up for oral argument. Again, major cases being decided by our United States Supreme Court in this term.
likely to be issuing decisions in May, June, July of next year. The ghost gun case we talked about before, that's Garland versus Vanderstock, whether or not the ATF can regulate these kits that you can get through the mail, through deliveries from private providers, and assemble guns. Are those firearms under the law? A major case as well involving other issues related to environment. The question of, in a case involving San Francisco and the EPA, whether or not a combined sewer and stormwater system complies with something called the National Pollutant Discharge Elimination System and the rules and regulations imposed by the EPA upon the city of San Francisco. Some disagreements there between a major American city and the EPA about wastewater discharges into the Pacific Ocean that includes some identified pollutants. And that case also, again, on the docket of the Supreme Court, among its many other cases. That one also raising issues about whether or not a federal agency has the discretion, the authority to act as it has. We talked previously about this case involving Glossop versus Oklahoma, a defendant who is on death row. And in the wake of being placed on death row, the death penalty imposed upon him, discovery that the prosecution during the course of the underlying trial basically presented evidence of a witness who committed perjury and therefore denied the defendant a full and adequate opportunity to defend himself. Glossop versus Oklahoma, a major death penalty case, involving deceptive advertising, involving cannabis medication, THCs, and CBD-based medications. That case is medical marijuana versus Horn. Not so much a medical marijuana case, but more of a deceptive practices case. Other cases involve questions of whether the federal government is authorized to license a private company, a private entity, to temporarily store spent nuclear waste at a location away from the nuclear plant at which that fuel was generated. That case involving the state of Texas, coming out of the Fifth Circuit once again. That's involving another agency called the Nuclear Regulatory Commission. There's another case called Seven County Infrastructure Coalition versus Eagle County, Colorado. That's a mouthful. Basically, again, another environmental case questioning whether or not the National Environmental Policy Act, sometimes called NEPA, requires what we all know as environmental impact studies conducted by that federal agency. Can they extend beyond the proximate effects, the immediate effects of actions over which the regulatory authority is clear? Can they go beyond the specific assignment, the specific focus of the environmental impact study and discuss larger impacts? That also, there's a case called FDA versus Wager and White Lion Investments. And that is the name of the case, of course, that is the vaping case. It's coming up for oral argument just this week. A significant case in terms of not just the FDA, but also things in our commercial markets. A case called Stanley versus City of Sanford, Florida. Question about whether under the ADA, the Americans with Disabilities Act, that a municipality can or cannot restrict some health insurance benefits for a retired city firefighter after a disclosure that she is suffering from Parkinson's disease, an important issue under the ADA. Some other cases involving free speech. This one's called Free Speech Coalition versus Paxton. Yes, again, that's the Paxton of the Attorney General of the state of Texas. Can a state legislature mandate that websites with content that, according to the state legislature, is harmful to minors, they're talking about pornography, can those websites be required by state law to verify the age of every user without running afoul of the free speech mandates of the First Amendment? Interesting issue. Also being faced by one of our nations overseas, which we'll get to later in this hour. And then finally, another case among the 47, EMD Sales versus Carrera. This has to do with overtime pay. As an employer of current and former grocery distributor employees, are they liable for violations of something called the Fair Labor Standards Act, the FLSA, for describing those employees, categorizing them as outside salesmen and outside saleswomen, and so refusing to compensate them on overtime pay, an employment issue, those among the many cases being discussed, being considered among the 47, almost certainly go up to 60, maybe 62, maybe even more than that in this docket, this 2024-2025 docket of the United States Supreme Court. Now, reason why all of that is important is also that to the extent the government is involved in many of these cases, and they are, the environmental cases, certainly the guns cases, other cases involving civil rights and human rights, the Supreme Court has taken the position that the Solicitor General is the one who presents argument to the Supreme Court. Right now, her name is Elizabeth Prelogar. We know that in the incoming administration, there will be a new Solicitor General. His name will certainly be John Sauer. He's the one who successfully argued before the Supreme Court back in April of this past year that presidents have immunities for crimes committed in office. John Sauer is going to become the new Solicitor General arguing cases before the Supreme Court. And what is the point of all that? What's the point of discussing all these cases where there is significant controversy between the administration and other parties about what should happen? Well, the answer is that with the change in administration, not just the change in the Solicitor General, but also in the Department of Justice itself, the Solicitor General is one of the top officials of the United States Department of Justice, responsible to the Attorney General and the Deputy Attorney General. When John Sauer takes office, highly likely that the Solicitor General, through his office, the Department of Justice, through the Solicitor General, will tell the Supreme Court that we have changed our position, or more accurately, the administration has changed and the position of the Department of Justice on things like guns and civil rights and the environment has therefore changed as well. That will dramatically impact whether these cases go ahead, whether we in fact hear about opinions on these cases in June or July, or whether they are effectively mooted, effectively taken off the calendar by virtue of 180-degree changes in the position of the Department of Justice. The Solicitor General no longer advocating, for example, in support of the ATF rule prohibiting the selling of ghost guns in their non-assembled state. That will almost certainly change under the new administration. The rule that was imposed by the ATF almost certainly withdrawn, and therefore no longer a case in controversy. Highly likely will not get a decision by the Supreme Court, but we will get, as a result of that change in administration in the Supreme Court, not only the withdrawal of that case and others that we have talked about, but also when it comes to those issues, a change in our nation with respect to guns, with respect to civil rights, with respect to the environment, and all sorts of other things out there that are among those 47 cases in which the government has an interest. That is the other reason why when you elect a president, you're not just electing the president's policies and practices, and certainly the members of his or her cabinet, the other agency actions that may in fact be subject to that executive review. Not all of them are, but you're also having an impact upon the very ways in which decisions are made before the United States Supreme Court. With the change in administration come January 20th, many of these petitions, the arguments made up to this point will change as well, as will the ultimate decisions by the United States Supreme Court. No small impact here in our nation. As we continue, we're going to turn to other issues involving the rule of law on the face of our planet. Stay with us for that important discussion here on Amicus, a law review.
This is Amicus, a law review. My name is Jim Santelle, your host for this remaining hour of our weekend broadcast. Always interested in your inquiries, your questions at 855-752-4842. And that includes Mark. Mark, you've been on the line for a while. Glad to have you with us as a part of our weekend discussion.
Yeah, thanks so much, Jim. Yeah, it puzzles me that our Supreme Court is looking at stuff, and I guess maybe I'm misunderstanding, but in Federalist 44, Madison points out that they didn't expressly put in the Constitution everything possible the delegated powers that Congress might have to address the law. And I would think that could get passed over, that Congress can say that we have agencies now in the government that are going to be subject matter experts and able to address some of these issues, and, that we don't need to, Congress itself doesn't need to attend to every single minute detail of what the law is and how the law is going to be carried out, that rely on subject matter experts to do some of that stuff, which gets to Chevron as well. But as far as for the president having these supreme powers now, it just baffles me how the Supreme Court was able to get around the fact that, repeatedly in the Federalist Papers, Madison, I was looking at it today, and Federalist 72 said, no, we're not going to have, or I think it, maybe got the number wrong, but or 70, that we do not, the presidency is not going to be some Oriental despot. And what he meant by Oriental at that point, in the context of the time, was not some Persian Shah having janissaries at his disposal and, his personal harem. But with this president, I mean, he is talking about using the military as his force to express his will across the country. And Donald Trump has expressed in the past could go on Fifth Avenue and just murder somebody, just kill somebody, and get away with it. And with this Supreme Court, it is not beyond imagination anymore that Donald Trump could say that guy is my enemy, so that I personally choose to, it's my part of my official duties to take out my enemy. And Donald Trump is the state. I mean, that is not what we want to have. Is the president is not the state. He's not a king.
He is one of three branches, right? That's exactly your point. And again, Mark, I know you've read it. Others have read it as well. As stunning as that immunity decision is back in July, which continues once again to animate what is and is not going on in our courts, those first few pages of it are these incredible words of commission to a very strong president that has got to be muscular, has got to be able to respond very quickly and definitively to actions, cannot be bothered with things like criminal prosecutions, kinds of things that you're looking at even this morning in the Federalist Papers, Mark, all those kinds of things. That the establishment, Mark, your point is the establishment of that supreme presidency, along with a Supreme Court that once again is more and more relying upon itself and not the expert background and experience in all these agencies. This latest case, again, involving consumers research coming up for oral argument probably in the springtime, getting rid of yet another doctrine that, as you said at the outset, Mark, here, contemplated by Congress that there be delegations to agencies. Maybe we need to resurrect that non-delegation doctrine and say either Congress has got to say it or the agencies cannot do it. Once again, a great distrust in the agencies, even while we are advancing and promoting dramatically the power of the Supreme Court to make these calls, and, as you said, at the same time, advancing this notion of a supreme presidency. Along the way, one wonders, where is the Congress, right? Where is the Congress that should be the ones who are making these decisions? They were going to be the major institution in the Federalist Papers and the Constitution that does all this. Mark, appreciate your comment, your inquiry, and your observation very much, as always, here on our Saturday and Sunday broadcast here on Amicus, a law review. It is not, of course, only in our nation where legislation gets passed or not passed from time to time that has a dramatic impact upon the citizenry. Let's do a couple of rule of law snapshots here, which we haven't done in a while. Two things coming from Australia and from Great Britain that are worth note and worth discussion in the future, not only in those nations and the legislatures of those nations, but issues related to things on our docket, in our agenda as well. Australia just this past week imposing legislatively a sweeping ban a sweeping ban on social media for children under the age of 16. And again, this is one of the significant aspects of this. It is one of the most comprehensive measures aimed at so-called safeguarding young people from potential hazards online. And the law sets a minimum age, again, for users of platforms like TikTok and Instagram and X, for example. The issue now is how this restriction will be enforced. That's the big question, how it's going to be enforced on a day-to-day basis. The law, the prime minister who is supporting it, his name is Anthony Albanese, has said it puts Australia at the vanguard of efforts to protect the mental health and well-being of children from detrimental effects of social media, such as online hate or bullying. And certainly that happens a lot, as we all know, on these online formats, these online platforms, an attempt to keep our children, at least the Australian children, safe and secure at a time when they, in fact, are in their developmental stages. The law, the prime minister said, puts the onus on social media platforms to take what are called reasonable steps to prevent anyone under 16 from having an account off completely. Corporations could be fined up to 49.5 million Australian dollars. That's about $32 million in our system for systemic failures to implement age requirements. The law goes on to say that plainly the underage users, neither they nor their parents will face punishment for the violations. It places the burden, once again, of enforcement compliance upon the platform providers themselves. Interestingly, France last year passed a law requiring parental consent for social media users under 15. And it has been pushing for some similar measures, like things across the European Union in that part of the world. Florida, this past year, as you know, as we've talked, imposed a ban for users under 14 requiring parental consent for 14 and 15-year-olds. That law plainly the subject of an awful lot of challenge out there. But in Australia, barring everyone under 16 from social media, period, and now raising the question about enforcement. The purposes behind it, probably legitimate, although not without challenges plainly in their courts as that particular legislative piece goes ahead. It is one of those things that underscores the importance for courts and for legislatures and even for executives like the prime minister and presidents across the globe to address these issues in an evolving situation. Also underscores, of course, the notion that constitutions, whether they're Australian or American or in other nations, even systems of laws have got to be alive. They've got to be responding to the times in which the issues are raised, cannot be premised upon the history and tradition of society, because those do not give you an awful lot of guidance, especially when it comes to something like safeguarding young people, again, from so-called potential hazards online, things like X and Instagram and TikTok, Twitter, that people like James Madison could never have imagined to begin with. That happening in Australia. And then in Great Britain, lawmakers again, this time, of course, in Parliament, after a very, very emotional, times impassioned debate on Friday of just this past week, voted to do something dramatic, sometimes compared to Britain's legalization of abortion in 1967, the abolition of the death penalty there in 1969 being compared to significant changes of that dimension. What did Britain's lawmakers do? They voted to allow assisted dying for terminally ill patients there in that nation, England and Wales, under some strict conditions. And again, establishing one of the most profound social changes in that country in decades. The vote inside the parliament, 330 to 279. So you've got a split parliament there. Members of the parliament, in the end, giving their support that would permit doctors to help some terminally ill patients to end their lives. Now, the process there in their parliamentary system, like ours in many ways, this is not the final say on the matter. All of this will have to now go to some parliamentary committees and amendments to the bill may be put forward. But it nonetheless is a significant movement in this direction. The new legislation, as it is currently written, applies to a very narrow group. It's applicants who are over 18. You have to be an adult. You've got to be diagnosed with a terminal illness, and you have to have been given no more than 6 months to live. 2 doctors and a judge would be required to give their approval, and the fatal drugs would have to be self-administered. So a lot of safeguards in that area, but an important piece of legislation. Importantly, again, as we look around the globe, assisted dying is already legal in a handful of European countries. And that includes, among other countries outside of Europe, Canada and New Zealand. And here in America, 10 states and the District of Columbia also have assisted dying legislation. All of that, again, proposed by the Labour Party there in Great Britain. And lawmakers, again, appropriately being given by their parties freedom to vote with their consciences instead of expecting to be voting along party lines according to their particular dictates of their own conscience. That's what the leaders of the parties there in Parliament contemplated. 5 hours of debate on Friday, crowded parliamentary chamber, raw divisions, lots of emotion over an issue that transcended political affiliations and will again change the social fabric, undeniably, of Great Britain if indeed the law goes forward. It has hurdled this major, major step already in Great Britain. Lawmakers voting to legalize assisted dying in this major legislative move just this past week. Those things happening, the rule of law, certainly not the last comments, not the last words on those issues in those nations, certainly not in our nation as well. And so let us return to the United States of America for a couple more things that happened just in recent days and weeks here in the United States of America. Texas, which again gives rise to an awful lot of those federal cases now pending before the Supreme Court. Texas, of course, right there in the Fifth Circuit Court of Appeals. Texas, this past week, its education group, its curriculum group, just on Friday, approved a revolutionary new elementary school curriculum that is premised principally upon the Bible. And this, of course, is a major step in this contentious argument there in Texas and now spreading around the country. Oklahoma has similar arguments and disagreements and discussions going on to expand the scope of religion instruction in the state. This particular education policy that was adopted on Friday, the reading and language arts curriculum, which is where it's found, is going to be optional for schools, but it could serve plainly as a model for others throughout other states. Its approval, once again, as I just mentioned, comes as Oklahoma superintendent, you know this well, seeking to compel all educators in that state to teach from the Bible. Also, not too far away, Louisiana has fights in its courts to require the 10 Commandments be displayed in classrooms. Now, we know well what the law is in America. Way back in 1963, the United States Supreme Court said you cannot have religious instruction in public schools. Private schools, entirely appropriate, entirely within their discretion to do what they want. Public schools, that's government. And again, cannot establish a religion. This comes from the First Amendment to the Constitution. No establishment of religion in schools, which includes government, of course. The other portion of the religious phrase, that a religious doctrine there is, you can't affect the exercise, can't impinge upon the exercise of religion in America. But this is a question of whether or not you are establishing a religion in a public setting. In 1963, the Supreme Court said, nope, cannot stand in front of a class and teach from the Bible. Cannot do that. Now, people say often, well, gee, you've prohibited any sort of Bible references or uses in schools, and the answer is no. The Supreme Court has been equally clear that you can indeed read the Bible privately. You can pensively in a study hall, other circumstances, have a Bible with you as a student. You cannot teach from it. You cannot teach in a religious type format directly from the Bible itself. Bible-based lessons are unconstitutional. And yet, now we have in Texas, arguably in Oklahoma, arguably in Louisiana, other places around the country, this pushback and attempt perhaps to revisit this issue once again under the First Amendment. When we come back, we'll talk more about Bible-based lessons for public schools here on Amicus, a law review.
This is Amicus, a law review. My name is Jim Santelle, and we are talking in this, the final segment of our weekend broadcast, about things going on here in the United States of America, specifically in states like Texas, other places in our nation, attempting to roll back what has been the law since 1963 in America, and that is you do not teach in public schools directly from Bibles. And again, in Texas, the final approval just this past week by their curriculum board, finding that indeed this curriculum that is for kindergarten through fifth grade, available to districts, it will serve the state serves about 2 million elementary students in public schools. What does the curriculum do? It incorporates into English lessons stories from the Bible, such as Jesus and his Sermon on the Mount, the parable of the prodigal son, and the Old Testament tale of Esther. Now, what can you do and what can you not do? Well, once again, you cannot stand in front of a class and say, we're going to be teaching from the Bible itself, but you can indeed teach, for example, the history of religion on the face of the planet. You can talk about any of the major, even some of the minor religions that have animated the history of human civilization. That, of course, includes not only Christianity, but Judaism and Islam and Sikhism and Hinduism and Buddhism and many, many others, Jainism, many, many other very well-established religions. You can talk about the history of religion, make that not only a history course, but also describe where those religions come from, what some of their principal tenets are, those kinds of things, without what's called proselytizing. You cannot encourage students to become adherents to a particular faith. On Friday in Texas, the Texas State Board of Education approved this curriculum in a narrow 8-7 vote, 3 Republicans joining 4 Democrats on that board in an effort to reject it, but nonetheless it's successful. The state's individual districts and the schools will ultimately decide which materials to teach, but they are financially incentivized. They're encouraged by this program to adopt curriculums that are specifically approved by this board. Needless to say, causing a huge amount of discussion there, igniting a fierce backlash, hundreds of Texans protesting for months at meetings of the State Board of Education in advance of this voting. And the state's largest teachers union, many parents, including Christians, arguing the lessons blur this constitutional distinction. They blur the distinction between instruction on religion and proselytizing, and present scriptures, as they say, as factual truth to children as young as 5. That going on now in Texas. Again, lots of things to consider there, and plainly encouraging rising argument, ultimately probably geared toward returning to the Supreme Court one day and determining whether or not that 1963 prohibition and like prohibitions that followed, including the prohibition on posting the 10th Commandments in places of public instruction and places of public industry and commerce. That also a part of the constitutional history of our nation that remains the law to this day. Probably an attempt by these various groups in Texas, other places like Louisiana, like Oklahoma, an attempt to begin to move in the direction of seeing if we can overturn that long-standing tradition of now well over 40 years or so. Interesting intellectually, interesting constitutional issue under the First Amendment. And of course, the Supreme Court in the past, as we have talked, is very interested, has always been interested in recent terms in this issue, not only of establishment of religion, but also the free exercise of religion. John Roberts, the Chief Justice, being at the forefront of this change in the way in which we evaluate whether or not the legislation of a particular state or by the Congress is establishing religion. An action is somehow impinging upon that establishment principle, or also impinging upon the right to exercise religion freely. The Chief Justice more and more beginning to articulate a standard that says if the provision, if the legislation in some way discriminates against or affects in some way negatively a religion, that is prohibited by the First Amendment. Interesting times, interesting applications of the First Amendment. This one, once again, plainly pushing the limits on what the First Amendment does and does not say in contemporary America. We'll continue to look at those cases as they go forward. And finally, here on our weekend broadcast,
Some notations about other things going on in America. Major indication that white supremacist incidents are rising again across the United States of America. Things called flash demonstrations that are intended to spread fear and anxiety, happening almost weekly by a number of different groups reporting on these things. Again, fairly recently, they've always been out there, but an increase of dramatic dimension. The Anti-Defamation League has recently reported about 282 events organized or attended by white supremacists in 2023 alone. That's a 63% increase from the 173 recorded in 2022. In 2024, this year, from Memorial Day to Labor Day, there were 64 white supremacist activities in 25 different states, according to, again, this Center on Extremism, also supported by other groups that are also monitoring this kind of thing. Those included what are called fight nights, mixed martial arts style events held for supporters to socialize and recruit members and raise money, all for their racist and their otherwise inappropriate advocacies. The experts who are monitoring this describe this according to some familiar patterns. They say small groups of mostly masked men chant, and they sometimes wave swastikas, white power flags in public. They yell racial slurs at targets. Those targets, of course, are varied. They're diverse. They're immigrants. They're members of our Black community, the Hispanic community, people of color, Jews, LGBT community members. The activities, again, of these relatively small but unidentified, at least individually, groups, they unfurl some offensive banners with epithets about those groups. They do them over highways. They post racist flyers in communities. And the demonstrations are typically also captured on video. And the purpose for that, according to these groups that are monitoring this, is for purposes of recruiting more, to further raise money, to recruit members, to socialize among these groups. They ricochet sort of across social media to larger audiences, even though the groups themselves may not be that large in the particulars. For example, a neo-Nazi group scattered flyers across lawns and doorsteps in 3 Waterloo, Ohio neighborhoods just before Veterans Day this past year. The handouts offered a chilling assessment of the group's proximity. In capital letters, they said this: "We are your neighbors. We are the random stranger holding the door open for you. We are everywhere." Very disturbing reporting coming out, reporting on white supremacist incidents across our nation. Next week, more of that, more of reporting on what's going on in America of 2024, as we look also into the politics and also the government, the rule of law, the administration of justice in 2025 and beyond. Have a good weekend, everybody.